Good afternoon, everyone. Welcome to our August CLE over landlord tenant issues. My name is Kristen Salas. I am one of the mentor attorneys at the Dallas Volunteer Attorney Program. And for those of you that are not familiar with DVAP, as we call it for short, we are a joint project with Legal Aid of Northwest Texas and the Dallas Bar Association. And our primary focus is to match low-income Dallas residents with private pro bono attorneys that will work their case from start to finish. One of the many types of cases that we take are landlord tenant issues, and that ranges from a wide variety of issues, from trying to get a return of security deposits to repair issues to evictions. So today we have Mary Ann Danello, who is going to be talking to us about everything you want to know about landlord tenant law and oh so much more. Mary Ann is a graduate of SMU. She is the supervising attorney at the Housing, Consumer, and Economic Benefits Division of Legal Aid. She joined Legal Aid way back in 2005 as the hurricane relief liaison in the wake of Hurricane Katrina, and pretty much revised that role again when Harvey came through. During her career at Legal Aid, she's worked primarily in the housing and benefits area, worked closely with the Housing Crisis Center, and still oversees the Housing Crisis Center clinic that happens, I believe, twice a month. We are so grateful that she has also served as our mentor for landlord tenant issues and continues to do so. So she is a wealth of knowledge. And as she goes along, if you have questions, do feel free to put them in the Q&A at the bottom. And if we have time at the end, we will go through them. So without further ado, I will turn it over to Mary Ann.
Thank you, Kristen. I will go ahead and start sharing my screen right now so that we can get started. Kristen, if you could let me know when everybody can see my screen.
We can see it, or at least I can.
Okay, great. Then I will get started. Welcome, everyone, and thank you for your time today and joining this particular CLE for landlord tenant law. We're going to be talking about evictions and other common issues. Hold on, I'm sorry, my screen is not tabbing. There we go. So today we're going to first talk about the landlord-tenant relationship, the eviction process. I'm going to talk about COVID-19 and its effect on evictions and landlord-tenant issues. And then we're going to cover some of the most common issues that DVAP sees and that we see at the Housing Crisis Center Clinic, such as lockouts, utility interruption, repairs, landlord liens, domestic violence, reasonable accommodation, sexual harassment, and then we're briefly going to talk about federally subsidized housing. So to get started, the first thing you've got to look at when you're dealing with a tenant or someone who thinks they're a tenant is to analyze whether or not an actual landlord-tenant relationship does indeed exist. If you've got a written lease, great. You can check it off. The parties have definitely agreed to enter into a landlord-tenant relationship, so your analysis can stop there. But if you don't have a written lease, you've got to then look at the relationship between the parties. There could be an oral lease, but the payment of rent, or what someone is calling rent, is not dispositive when it comes to whether or not a landlord-tenant relationship actually exists. In Texas, under Texas law, it's whether or not the parties intended to establish such a relationship and the owner or lessee has transferred the exclusive possessory rights of all or some of the residents. So courts are evaluating the relationship as a question of fact, and you really do need to look at the interaction between the parties. It could be that the person who is claiming to be a tenant is actually a guest or an invitee. And if that's the case, then they don't have the protections of a tenant and no formal eviction process is needed. Now I put it under here an example. Auntie M does not have to evict Dorothy. So in my example, Dorothy is now all grown up and she's now an adult, and but she's still hanging around with some suspicious characters, and she's living with Auntie M in the house, but Auntie M no longer feels comfortable because of the company that Dorothy keeps. Maybe money is missing from her wallet, maybe people are having wild parties, maybe objects are going missing. Does Auntie M need to evict her? No, because Dorothy is living with her, but Auntie M has not granted the exclusive possessory rights of all or part of the premises. She's simply sharing the home with her. So in that type of relationship, and we see this a lot with older children living with their parents, adult children, and whatnot, there is not a landlord-tenant relationship. We also see this in the instance between boyfriend and girlfriend. Girlfriend owns the home, boyfriend is living there, maybe he's helping to pay the mortgage. They break up. Does she have to evict him? No, the answer is she does not, because he is not a tenant. She never granted him, they were sharing the home, he never got granted the exclusive possessory rights to the premises. Now we do see problems in this. Well, you can say, how does she get him out? She can change the locks. And then as long as she provides him access to the personal belongings, she would not be guilty for conversion. Unfortunately, the problem comes in is that many times the police officers, when they get called, tell the homeowner that they have to go through the eviction process, which is inaccurate. It's bad advice. They're playing attorney, they're playing judge. They shouldn't be giving that advice, because there is a remedy if they are a tenant called a writ of reentry, and we'll be talking about that later in the presentation. So there is a remedy if they are a tenant to get back in. But if we're looking at the law, boyfriend-girlfriend situations, Auntie M doesn't have to evict Dorothy. We also have the motel and hotel guests. Many times we have at the clinic, extended stay hotel guests are coming to us and they're saying, they told me to get out or they locked me out. Don't they have to go through the eviction process? And the answer is generally no. Occasionally, if it's long-term and payments are made monthly, there may be an argument that a landlord-tenant relationship exists, but usually the motels and hotels are very careful to make sure that that relationship does not become one of a landlord-tenant. And so those individuals do not have the right to the tenant, and they do not get, the owners of the property do not have to go through the eviction process. When we're looking at lease agreements, you want to look at what type of lease agreement it is. It can be a fixed term tenancy, or there could be a tenancy at will where there's a landlord tenant relationship, but there are not specific terms of the tenancy. Often verbal agreements are tenancies at will. And then there's the periodic tenancy, which an example of that is a month-to-month tenancy. So those are your types of lease agreements that you have. Practical tips here: if there's no lease agreement, title might be at issue. Keep in mind that justice of the peace courts have original jurisdiction over eviction suits, but they cannot determine title. So if title is at issue, an eviction suit cannot proceed in the justice court. Also, if the tenant did not get a complete copy of his or her lease agreement, an eviction suit can be abated if the landlord hasn't given them the copy, but this is only for non-rent breaches. This does not apply to a non-payment of rent case. So if the tenant is being evicted for any non-rent breach and the landlord has not provided a copy of the lease agreement, that eviction may be abated until the landlord does provide the tenant with a copy. So now we're going to go on to the actual eviction suit itself, or what is technically known as an FED suit, forcible entry and detainer suit. Here's a quick overview of the eviction suit. First, the tenant has to violate the lease, or the landlord alleges that the tenant violates the lease or is a holdover. Next, the landlord needs to give a notice to vacate as a predicate to filing the eviction lawsuit. After the notice to vacate expires, the landlord can file a petition in justice court. The citation is issued and the tenant is served. An eviction trial will take place in justice court within 10 to 21 days after filing, and the only issues are possession and rent. The landlord can then obtain an eviction judgment for possession. The tenant has only 5 calendar days to file an appeal with the county court. And if the tenant does not file an appeal with in that time or perfect the appeal, the landlord can obtain a writ of possession and which the constable will enforce. So that's a brief overview, and we're going to talk about the different steps in just a moment. First of all, we've got to talk about the violation of lease. And up here I've put there's non-payment of rent and everything else. So non-payment of rent is the biggie. In Texas, day late or $1 short, too bad, so sad, they can be evicted. It's important to note that the grace period is not the due date. Many times when I ask a tenant, when is your rent due, they will tell me the 3rd or the 5th of the month, because they've got a 3-day or a 5-day grace period. But if you look at their actual lease agreement, it's the 1st of the month. And so rent is late when it's not paid on the due date. And it's important that tenants understand, and that advocates explain to tenants, that a landlord has no duty to accept rent once it becomes late. The only time a landlord under Texas law is required to accept rent, is when it is tendered on time and in full. That is the only time a landlord has to accept rent. Now, why might a landlord not accept the rent when it's late? Well, we often see this, and an example would be senior citizens. Senior citizens are usually fairly good tenants. They're not having wild parties. They're not growing pot in the closet, but they may have a lot of time on their hands, time to do some research about their rights, and time to hold the landlord's feet to the fire on every little thing. They can become a little bit of a nudge in the landlord's side, but they pay their rent every month like clockwork. Well, sometimes maybe it's a holiday, maybe the Joe Senior was out of town on the 1st, but one day they go in and they tender the rent on the 2nd instead of the 1st of the month. Now the landlord can say, nope, I'm not going to take it, and go ahead and evict for non-payment of rent. Is it fair? No. Is it legal? Absolutely. So one of the first things that I tell tenants when they're having any kind of issues with their landlord is I ask them, when are you paying rent? And if the answer is anything other than the due date, I advise them to start paying on the due date and not to give the landlord an easy out, an easy way to evict them. Now, also, we want to talk about late fees. In order for a landlord to be able to charge late fees, there has to be a written lease, and the late fees have to be in writing. Under oral agreements, late fees cannot be charged, so it must be in writing. Also, it's important to check for a payments clause in the lease agreement. Payments or an applications of funds clause. Both the TAA, the Texas Apartment Association lease, and the TAR, Texas Association of Realtors lease, which are the 2 most common leases we have in the Dallas-Fort Worth area, have this clause in their agreements. And what this clause says is that all fees and fines are due upon demand other than rent, and that when they're not paid, and when rent is paid, that it first applies to any outstanding fee or fine before rent. Now, what that happens and what happens there is sometimes people will pay rent late, but they don't pay the late fees. And the next month, they go to pay rent and they pay rent on time, but they haven't paid the late fees from the previous month. So that rent that they pay the second month goes first towards the late fees of this previous month. Therefore, rent is not paid in full for the second month and late fees continue to accrue. So you can see how this can snowball. Sometimes what happens is several months later, the tenant is being evicted for non-payment of rent and comes to you and says, hey, wait, I always pay my rent. I've paid it. And it's only by looking at their receipts that you'll see that maybe 4 months previously, they paid late, but they never paid the late fees. And so now they're being evicted for non-payment of rent because their rent kept going to the late fees because of this applications of funds clause. So it's important to check that in the lease agreement. It's also good to note that the landlord has no obligation to remind the tenant about late fees. The tenant's notice is the lease agreement. So if the landlord never tells them and starts evicting them 4 months, 6 months later for late fees, they can do it because there's no obligation to remind them that they have late fees due. Now, other violations that I've put some examples here, this is not an exclusive list, but would be criminal activity, drug use, damaging property, unauthorized occupants, and unauthorized pets. These are common non-rent issues that we see people being evicted for. When you're looking at a violation and it's not a rent violation, you want to make sure that you read the lease agreement to see if it is an actual violation of the lease. You also then want to check to see if a reasonable accommodation could excuse the violation. And a couple of examples that I've put here is, let's say rent is due on the 1st, but the tenant receives SSDI, a disability payment, and that's their only form of income, and they get paid every month on the 3rd. Well, HUD has determined, and Fair Housing has determined, that if a tenant requests a reasonable accommodation to make their rent due after they get their disability check, that is a reasonable accommodation, and the tenant can request that at any point before the eviction trial. The tenant, let's say, has a dog, but that dog is an emotional support animal. So that would be a reasonable accommodation. And then another example I've put down is, let's say the tenant yelled at a neighbor, caused a disturbance, but they suffer from bipolar disorder and they were temporarily off their medication. Again, this is going to be situational specific. You've got to look at the totality of the circumstances. Certainly, if this tenant has a long history of not being on his medication, that would not necessarily be something you could ask a reasonable accommodation for. But if it's a one-off situation, it is something that a reasonable accommodation could be a defense to an eviction or a notice to vacate. So there has to be a demand for possession prior to the eviction lawsuit. The notice to vacate must be given. This has to be an unequivocal demand for possession. It must be in writing, not via text, not over email, and it has to be delivered properly. It can be hand delivered to any person, to the tenant or anyone who answers the door who's 16 years of age or older. It can also be affixed to the inside front entry door, sent by mail, or it can be affixed to the outside if and only if there's a reason the landlord can't get inside, such as the tenant has put on an additional lock, or perhaps it's not safe to go in because maybe they have a dog in the property. In that case, and in only that case, they can affix it to the outside, but it must be in an envelope, labeled important document, and it must be put in the mail the very same day in order for the notice to vacate to count. Also, when you look at the notice to vacate, you want to make sure that enough notice was given. Now, the lease agreement is going to control here as to how much notice needs to be given. And under the law, it can be as little as 24 hours. Again, both the TAA and the TAR leases in the Dallas area have the 24-hour provision. So if you've got one of those leases, they can give a 1-day, 24-hour notice to vacate. If the lease is silent, however, the property code states that it must be a minimum of 3 days. Subsidized properties often have extra requirements and may have an extra requirement that they have to follow before they can even give the notice to vacate, such as in federally subsidized properties. And we'll talk about that towards the end of the presentation. You want to make sure that it was delivered properly and can be verified. Often tenants will say that it was slipped under the door or put in the crack of the door. If they've taken a picture of it, that's some good evidence that that was the way it was delivered. If they come into court and the maintenance man delivered it, or some other employee that is not there to testify in court that they hand delivered it, that could be a defense to delivery if they do that. They also want to make sure that the landlord waited the correct amount of time before filing the eviction lawsuit. So if they gave them 3 days, you want to make sure that they waited until the 4th day before they went and they filed. If they filed before that, you've got a procedural defense to the eviction. And we often see landlords jump the gun and file just a little too early. The eviction suit itself, the landlord has the burden of proof. That being said, many JPs will give the landlord the benefit of the doubt. So I tell tenants they want to go in prepared with a defense, because if it's a he said, she said, it's really not a 50-50 situation there. Often, and my theory is that because the landlord is the one suffering the economic harm, especially if they're evicting a paying tenant for a non-rent breach, the judges tend to give the landlord the benefit of the doubt in he said, she said situations. But the landlord does have the burden of proof. If only one party shows up, the other party loses, and that party wins by default. Loser pays the court costs and attorney fees if they're awarded. And the court cannot award anything other than possession of the premises and then unpaid rent if non-payment of rent was alleged. The court cannot award late fees, cannot award repair costs. All of those would have to be brought in a separate suit. And as far as the tenant is concerned, there are no counterclaims permitted in an eviction lawsuit. An eviction lawsuit at its heart is about possession. It's who has the superior right to possession of the premises. That is what the judge must determine. Once the judge determines who has the right to possession, the only thing the judge can do in addition to that is award back rent. Now, sometimes tenants don't actually realize they've been evicted. Many times tenants will show up to the clinic and say, well, I went to court, and I said, and I'll ask them, were you evicted? And they'll say, no, I wasn't evicted. The judge just told me I needed to pay. Well, that tells me they were evicted and they didn't understand what happened in the courtroom. Because in order for the judge to get to that judgment of payment, they had to first find possession for the landlord. I really wish that the JPs were clearer in their judgments, but unfortunately, many of them are not that clear, and the tenants don't really realize what happened, and frequently will miss their appeal window because they think all they have to do is pay, and that they haven't been actually evicted. And it's important to explain to tenants that they need to pay once they've been evicted. They're required to pay whether they stay or go. Payment of what they owe does not reinstate the lease and does not allow the tenant to remain. They'd have to enter into a new agreement if they wanted to remain with the landlord. Many tenants think they don't appeal and they come up with the money and they pay the landlord, and then what happens is the writ of possession issues and the constable shows up and the tenant says, hey, wait a second, I paid. Owe that amount. There's a judgment has been made against them, whether they stay or go. And it's important that you explain that to tenants and that they understand that. The eviction hearing, as I stated earlier, will be held not less than 10 days, but not more than 21 days after the lawsuit is filed. So they're very quick lawsuits. The lawsuit itself must include a description of when and how the notice to vacate was delivered. Often an alternative method of service will occur in an eviction suit. The constable will try one time to hand deliver the lawsuit to a tenant, and then the judge will usually sign off on alternative service and it'll get mailed out. Sometimes tenants who may be familiar with other lawsuits think that dodging the constable means that they can't be evicted. Unfortunately, that is not true. Non-attorneys can represent in an eviction case. It is not required for the landlord to have an attorney represent them in an eviction. Their property manager can do it for them. So when we're talking about eviction suits, some practical tips here is to know when to negotiate, to consider eviction hold-off agreements to try to get an agreement between the parties, and to remember that there are no counterclaims in an eviction lawsuit. So common defenses, obviously proof of payment. If it's non-payment of rent, the only defense is proof of payment in full and on time. Another defense is retaliation. Now, retaliation will never be a defense to non-payment of rent, but it can be a defense to any other non-rent breach. And retaliation would be a situation where, let's say, a tenant requested repairs, they didn't get them, and they made a complaint to code compliance, and the landlord was evicting them because they made a complaint to code compliance, or came up with, maybe perhaps they are not citing that as the reason, but the tenant may allege that the real reason is retaliation, and it's the reason that the landlord cited in the eviction lawsuit is just a pretext for the eviction. Defective notice or no notice, proving up the delivery of notice. These are all defenses. Discrimination, novation, not the correct party. It's always good, and I put a note here, check the Secretary of State website, especially if the party is an organization or an incorporation. How are they registered? Who owns the property? Check to see who owns it. Sometimes they file suit in the wrong name and they're not the correct party, so that can be a defense. If title is at issue, obviously the justice courts do not have jurisdiction. Unclean hands. Filing too early. Family and domestic violence can be an issue. Someone cannot be evicted because they're a victim of domestic violence. And another thing that we've looked at with organizations is sometimes their franchise fees have not been paid and they don't have the right to file suit. So it's important to look at these. Some of these are procedural defenses that can buy your client some time if the landlord has violated any of these. So now I want to briefly talk about COVID-19, and we're going to discuss the CARES Act, the City of Dallas Ordinance, and the TEDP, or the Texas Eviction Diversion Program. So the CARES Act, the Coronavirus Aid, Relief, and Economic Security Act, gave renters a number of protections that has since expired. However, one thing that has not expired and continues is the act does require some landlords to give a 30-day notice to before they can give a notice to vacate under than Texas law requires. And this is for non-payment of rent cases. If it is a landlord with a federally backed loan, or public housing or tax credit properties, project-based Section 8, housing choice vouchers, or the rural voucher program, any of those landlords are required under the CARES Act before evicting for non-payment to give the tenant a 30-day notice. Now, many of these landlords still think they only have to give the 24-hour or the 3-day notice. So this can be a procedural defense to many evictions. And you want to check to see whether or not the landlord is in one of these categories. Public housing, low-income tax credit housing, most of the time, and if they're on any of these particular programs, the tenant knows it and can tell you. And you can also look for tax credit properties online. If it's a housing choice voucher, they know whether or not they have a voucher. They know whether they're on a rural voucher program. So they can often let you know whether they're on any of these programs. If it's a private landlord, then the issue is whether they have a federally backed loan. On this next screen, I've given you 3 different ways that you can check that. There's 3 different websites that you can go to check to see if the landlord has one of the a federal loan. Now, unfortunately, they're not all inclusive. Could they possibly be missing one? That's a possibility. But these are really good, fairly reliable websites to check to see whether or not the landlord has a federally backed loan and whether or not that is a defense to the actual eviction lawsuit. The next thing I wanted to mention is the city of Dallas, and this is the city of Dallas only, not Dallas County, did pass a Dallas COVID-19 eviction ordinance. Now, what this ordinance says is that in non-payment of rent cases, so this does not apply to non-rent breaches, only non-payment of rent. If a tenant fails to pay rent during the COVID-19 declared state or local disaster, a landlord must provide the tenant first, before the notice to vacate, a COVID notice of possible eviction. Now, this COVID notice should notify the tenant that the rent is delinquent and needs to provide the tenant a right to respond and cure delinquent payments. The tenants have 21 days, so they've got 3 weeks to respond to this notice. And during that 3 weeks, if the tenant responds with any objectively verifiable evidence that they are unable to pay rent due to a COVID-related financial impact, they then have 60 days from the date of the notice to cure. So 49 more days, because it's not 60 days from the day that they notify the landlord, it's 60 days from the date that the landlord gives the COVID notice of possible eviction. If the tenant has a COVID-related financial impact, they then have a total of 60 days to cure before the landlord is allowed to give the tenant a notice to vacate. Now, often what we see is tenants get this notice when landlords do give it, and they let the 21 days expire without responding. And so then they get the notice to vacate and the landlord can go ahead and proceed with the eviction. If the tenant has come to you before the 21 days has expired, you want to find out, have they had a COVID-19 related financial impact? And do they have any evidence that they can show that's objective, such as their employer laid them off and they've got a statement from their employer that it was due to COVID-19 related financial impact. Unfortunately, 2 years out, there are very few tenants that can show this impact and get the total of 60 days now. But they do have to get at least the 21 days. So this is a good defense in many cases, but again, it's for City of Dallas residents only. It does not apply countywide. Um, Now we also have the Texas Eviction Diversion Program, or the TEDP. This program helps renters stay in their homes and tries to catch up on missed rental payments. I put the link for more information, and I do want to note that if even people on public housing or vouchers are eligible for the TEDP. Now, what I haven't put on here and is the link to rental assistance, because the TEDP program is out of money at this point in time. However, the program itself, as I'm going to explain it to you in a moment, is still in existence. So how does it work? When an eviction case is filed, the landlord's required to state in the petition that they've reviewed information on the TEDP, and all eviction citations under the Texas Supreme Court order are required to include information for the tenant about the TEDP. On the date listed in the citation for the trial, the judge has to discuss this program with both the landlord and the tenant and ask whether or not they're interested in the program. Landlords can refuse to participate and say, I don't want to participate, I want to proceed with the eviction, and the eviction will move forward. If they do, however, agree and are interested in the program, the judge delays the proceedings, so abates the eviction for 60 days. During that 60-day time period, at any point, the landlord can file a motion with the judge to reinstate the eviction case. The goal, however, is for that 60 days for the tenant to have an opportunity to get rental assistance. If rental assistance is made and there's no motion to reinstate the case, then the information on the eviction case becomes confidential and the case is closed, and that tenant is not evicted and does not have an eviction on their record. However, if the landlord does file a motion, the judge has to then reinstate the eviction case, set it for trial within 21 days, and the case becomes non-confidential and moves forward. If the landlord doesn't file the motion to reinstate, as I stated, the case is dismissed with prejudice, includes all claims, and the records remain confidential under the TEDP program. Unfortunately, we're seeing this less and less because there's very little rental assistance available. Now, just last week, if you saw the Dallas Morning News, the city of Dallas got $19 million in additional rental assistance. Again, it's only for city of Dallas residents. I can tell you that the Housing Crisis Center, the HCC, still has some rental assistance available, but many of the sources of rental assistance have dried up, and it's becoming increasingly difficult for tenants to find rental assistance, and fewer landlords are willing to participate in the TEDP program now. So moving on, I wanted to talk about some of the more common other issues that we see at the clinic and with tenants. And so the first one is lockout. In order for a tenant to be legally locked out, they first have to owe rent. That is the only legally permissible reason that a landlord can lock out a tenant. And before they lock them out, the landlord has to give them advance notice of their intent to lock them out. This notice must be either hand delivered or mailed 3 days if it's hand delivered before the lockout, 5 days if it's mailed before the lockout. The lockout notice needs to tell the tenant how much they owe, where they can go to pay, and when the landlord intends to lock them out. Once they do lock them out, if they've done it properly, the landlord must then post a notice on the front door telling the tenant how they can be reach the landlord to be let back in. And then the landlord, again, if they're following the legal process, they must provide a key within 2 hours of the tenant's request to be let back in. And this is regardless of whether or not they pay the rent. So you're probably thinking, why do landlords bother locking tenants out in the first place if they can only do it for non-payment and they have to let them back in even if the tenant doesn't pay? Well, I would say, having worked with tenants for over a decade now, my theory is there's two reasons why landlords, and I'm talking about landlords who do it properly, not improperly, still use the lockout process. And one is a significant number of tenants, once they've been locked out, simply leave. And that's it. And so it's a quick, easy way for the landlord to avoid having to go through the time and expense of the eviction process if they lock out the tenant and the tenant just leaves, and then problem's done. The other reason is a lot of times when tenants aren't paying, they're also not communicating with the landlord. So while the landlord has to show up and let them in, can the landlord ask them about the rent? Can't make it a prerequisite of letting them back in, but can the landlord ask about the rent and see if they can work something out? Certainly. So it's an opportunity for the tenant and the landlord to have a face-to-face meeting and a discussion about the rent. Now, what about those landlords that don't let them back in? Well, then the remedy there is a writ of reentry and or a suit for improper lockout. The writ of reentries are emergency lawsuits. You want to encourage a tenant to immediately file and to file early in the morning, because oftentimes if they file first thing in the morning when the courthouse opens, the judge will instruct their clerk to try to get a hold of the landlord that afternoon, and the judge can have an ex parte hearing if the landlord is unavailable to issue the writ of reentry. So often when the writ of reentry is filed, it is often issued in the same day. So the earlier they get to the courthouse, the better. If the landlord is found to have improperly locked the tenant out and the tenant has filed suit, the tenant can get actual damages, 1 month's rent, plus $1,000 attorney fees and court costs. So it can get very expensive for a landlord to improperly lock them out. It can also be some leverage for negotiation if the tenant only owes 1 or 2 months rent, because with the damages, their debt can often be wiped out. So it can be some negotiation there. The other thing that we see a lot with landlords is shutting off the utilities. Now, it's important to note that generally speaking, and this is only for landlord provided utilities, the utility company, if the tenant has the utilities on in their own name and they get the bill directly from the utility company, TXU, Reliant, Encore, whichever it may be, and they don't pay their bill, can the utility company shut it off? Absolutely. They can do that all day, every day. But if it's landlord provided utilities, either in that it's part of the rent or it's a separate bill, but they pay the landlord the utilities, generally speaking, the landlord may not cut off the utilities other than a bona fide repair or emergency. So this includes even if they haven't paid that utility bill or rent. Now, it does say in the property code, if the release provides for it, then a disconnection may be allowable, but it's subject to very specific requirements in the Texas property code. And I've put that code section there. I want to note that rarely do landlords get this right. It is the exception, not the rule, that they get it right. There's a laundry list of requirements that the landlord has to follow. And most of them do it incorrectly. It's easier and faster for them to just file an eviction for the non-payment than it is to go through this process of disconnection. If the landlord does shut it off and does do it improperly, the tenant may sue in justice court for a writ of restoration. The writ will entitle the immediate and temporary restoration of the utility services, and the writ of restorations are handled just like the writ of reentries in that they're emergency lawsuits. They can be generally heard the same day that they're filed, and the judge is allowed to have an ex parte hearing pending a final hearing to issue the writ. The tenant does have to file a sworn written complaint that specifically alleges the unlawful disconnection and state under oath in court the facts alleging the disconnection. A landlord's entitled to a hearing, but has to request one within 7 days. And the court may enter a judgment for court costs against the landlord that does not request a hearing. The court may also hold a landlord who disobeys the writ in contempt. So that's your writ of restoration. Landlord liens is another issue we see. In order for a landlord to be able to exercise a lien, there has to be a written lease agreement. This is not allowed in any oral agreements. And in order for the provision in the lease agreement to be valid, it must either be in bold print or underlined. It's got to jump out at the tenant when they read that lease agreement. And the reason is because no other notice is required. The landlord does not have to, like we were talking about before, the lockout. The landlord, unlike in the lockout in a landlord's lien, does not have to give a tenant advance notice of their intent to exercise a landlord's lien. Now, why is it? Well, think about it. If I was your landlord and I told you, hey, you didn't pay your rent this month, so tomorrow I'm going to come and pick up your TV. Are you going to have your TV sitting there waiting for me when I get there tomorrow? Probably not. So the only notice is the notice in the lease agreement. If the landlord does come in and exercises the lien, they are not allowed to take everything and anything. There is a list of exempt property that the landlord may not take. Examples of exempt property are food, clothing, work tools. There's a difference between work and your hobbies. If carpentry is your hobby, then all of those carpentry tools are fair game and the landlord can take them all. However, if the tenant is a carpenter by trade and it's how they earn it, how he earns his living, then all of those tools would be exempt. Children's toys are exempt, but the property code is specific here. They're talking about children's toys such as Barbie dolls, Matchbox cars. The Nintendos, the Wiis, the Xboxes, all of those are fair game because it's toys with which adults do not play. And adults play those electronic games all the time. Even if you personally don't play them, don't try to make that argument to the judge. It's adults in general. So it's talking about those, genuinely children's toys. And those other items, such as the Wiis and the PlayStations, are often big ticket items. And sometimes the first and only items the landlord will take. Why? Because people want them back. The landlord needs to create an inventory list of what he takes. He can charge fees for storage if the fees are stated in the lease agreement. And if the tenant doesn't pay their rent, that's how they get their items back. They pay their rent in full. The landlord may eventually sell the items at auction in order to recoup the rent. This is prohibited in both tax credit properties and public housing. But in private property, if it's in the lease agreement, a landlord lien may be exercised. And unfortunately, the property code does not include a limit as to when the lien may be exercised. It's just simply when the rent is delinquent. So can technically a lien be exercised the day after rent is delinquent? Yes. Generally speaking, landlords wait, considerably more time before it happens. Often tenants are more than 1 month behind, but legally, could they do it when on the first day that it is late? Yes, they can. Tenant repair process. We often see a lot of tenants come to us because they need repairs. It's important to note that under the Texas Property Code, rent has to be current in order for the landlord to have a duty to make repairs. Assuming rent is current, then the duty that the landlord has is a health and safety issue. So it's got to be a health and safety issue in order for the landlord to have a duty. This would be something like a rat or a roach infestation, a plumbing leak. All of these are health and safety issues. But what if, for example, the dishwasher is broken? Well, a broken dishwasher is inconvenient, but is not generally considered to be a health and safety issue. So generally speaking, under a lease agreement, unless your lease ensures that the dishwasher will be in working order, because the landlord could certainly contract for a higher duty, under the property code, the landlord would not have to repair a broken dishwasher because it's not a health and safety issue. How does the tenant get repairs? Can they make an oral request? Yes, they can, but their remedies under the property code are not triggered until they've made the request in writing. So we tell tenants to send their requests in writing, preferably sending it by certified mail, but it doesn't need to be certified mail. We often, the property code says that any form of tracking that the post office has are sufficient. Now, they're not required to send it. Can they hand deliver it? Yes. Can they stick a stamp on it and mail it? Absolutely. The difference is that if they don't send it through a tracking method, a second notice is required before the remedies are triggered. So once the landlord receives the notice, they've got 7 to 10 days to respond. If they didn't send it through a tracking method, then they need to give a second notice, wait another 7 to 10 days before they can choose their choice of remedies. Now, the property code gives several remedies to the tenants. The first one is a unilateral termination of the lease. If you're going to advise your tenant to terminate the lease, or that's what the tenant wants to do, what is important to note is that for that termination, you should urge them to definitely send it by certified mail. They should keep a copy of it. And they want to keep a copy of their lease and their requests for 4 years. The reason is because you can be sued on a contract, and a lease is a contract. There's a 4-year statute of limitations in the state of Texas. So if they're going to terminate, they may need to prove at a later point in time, perhaps when the landlord puts something on their credit report, that they breached the lease, or maybe if the landlord sues them for breach of lease, they may need to prove up that they had the legal right to terminate. So if they exercise the right to terminate, it's important that they're good record keepers and that they keep their records, just put it in an envelope with a do not destroy for 4 years on, and hold on to that if they exercise the termination option. The other option, if they want to stay but they want to get the repairs, is to file a suit for a writ of repair. These are quick lawsuits in the justice court. They're generally heard within about 2 weeks of filing, so they're very fast, and the tenant can ask the judge to order a writ of repair. Now, it's important that the tenant continues to pay rent and remain current throughout this entire process. The only time a tenant can stop paying rent is if they get a judge's order that abates the rent. And in the writ of repair lawsuit, they can certainly ask the judge to abate the rent, but they have to continue paying unless they get that order. There is an option, if you've looked at the property code, for repair and deduct. I never advise tenants to exercise this option because I can tell you, since working with I've been working with tenants since 2007, and I can tell you the exact number of tenants that I have seen follow the repair and deduct process and do it correctly, because that number is 0. If you look at that section of the property code, you'll see it is for a very narrow set of circumstances, such as sewage overflow. And in addition to that, it is a very complicated and time-consuming process. It is faster, in my legal opinion, to file a repair lawsuit and get a judge's order than it is to go and do the repair and deduct process themselves. Frequently, what I see is tenants who attempt to do the repair and deduct do not follow all the steps. And what happens is they end up paying for the repair and they end up getting evicted for non-payment of rent. So I never advise that. If you're going to advise that the tenant repair and deduct, look at that property code, walk them through it, represent them, don't just advise them, because frankly, they will screw it up. And it is a very complicated process. Wanted to mention the Fair Housing Act. The FHA prohibits discrimination on the basis of race, color, religion, sex, national origin, familial status, and disability. We're going to touch on this briefly. If a tenant comes to you and alleges discrimination on the basis of this act, this is where they can file a fair housing complaint. The City of Dallas Fair Housing Office. If it doesn't fall in their jurisdiction, they will refer to HUD. I often encourage tenants to go in person because the Fair Housing Office will investigate all fully completed complaints. So they've got to complete the complaint and fill it out in its entirety. And they do investigate all of their complaints and will refer to HUD if it falls outside of their jurisdiction. One of the things that we have come up with and that tenants have asked us is whether or not COVID-19 can be considered a disability. And here the law is not dispositive. There's arguments on both sides. Some argue that COVID is an infection that is a short-term condition and that it should not be regarded as substantially impairing major life activities. However, the alternate argument is that the American with Disability Act's amendments of 2008 can be considered persuasive in interpreting the FHA. And courts have found that an impairment is not categorically excluded from a disability simply because it is temporary. So courts have recognized the definition of disability should be construed in a broad coverage of individuals to the maximum extent. So there's your two arguments. There has not been any case law resolving this issue. I have had people make arguments on both sides of the fence. And so there is not a dispositive answer as to whether or not being infected with COVID-19 can be considered a disability. If someone has a disability, any disability, the Fair Housing Act prohibits the refusal to make reasonable accommodations in the rules, policies, practices, or services when the accommodation may be necessary to a person with a disability for the equal opportunity to use and enjoy the premises. It's important to note that a person does not need to be on disability benefits in order to meet the definition. So I've included the definition here for you. It's an individual with a physical or mental impairment that substantially limits one or more life activities, who's regarded as having such an impairment and has a record of such impairment. A reasonable accommodation does not have to be made in writing, the request. However, I strongly encourage tenants to put the request in writing so that they have evidence that they've made it, and whenever possible, to accompany that request with a letter from a medical provider to support it, because not all disabilities are obvious. For example, someone in a wheelchair, it would be obvious that they need a ramp. However, someone who is highly allergic and cannot have carpeting in the unit and needs some other type of flooring, that is not obvious from simply looking at the individual. And the landlord is allowed to request additional documentation. So rather than making the landlord go through that step, it's often wise to go ahead and accompany the request with a letter from a medical provider. If it's an exception or a change to a policy or practice or service, that is certainly easy for the landlord to do. However, it may be, if it's something like installing a ramp for someone who's in a wheelchair, if it is a public housing, then it must be done at the landlord's expense. However, if it is private housing and the accommodation costs the landlord anything, they are allowed to charge the tenants and pass that cost on to the tenant if there is any cost in making the accommodation in private housing. A note about sexual harassment. The two types of sexual harassment are quid pro quo and a hostile environment. Sexual harassment obviously is illegal, and if they have anyone has experienced sexual harassment from a landlord or his employees, I urge that tenant to either contact legal aid and or make a complaint with their local fair housing agency and or HUD. And that is another issue that we see. On a final note, I wanted to talk about federally subsidized housing. Federal subsidies include public housing, vouchers such as Section 8 or VASH, which is Veterans Affairs Supportive Housing. There's generally greater protection for tenants in subsidized housing and more obligations. I'm giving you a comparison of types of subsidized housing on the next screen. In public housing, the landlord is the public housing authority. So like DHA, the Dallas Housing Authority, would be the landlord. The PHA agrees to evict only in accordance with certain federal rules. Instead of just getting a notice to vacate, in public housing, a tenant has to get a 10-day notice of proposed lease termination. During that 10 days, they have the right to request a meeting with the landlord to address the issues that were the result of the proposed notice. The landlord can must do this before any other notices. So they cannot give a notice to vacate until they've given the proposed lease termination. And the tenant may have a right to a formal grievance administrative process if there's no criminal activity. The only exception here is if they're alleging criminal activity, they do not have to give them a grievance hearing. They can move forward with the notice to vacate and the eviction. But if it's for any other reason and the tenant properly within the 10 days requests a grievance hearing, then the PHA has to go through the administrative process to go ahead and before they can move forward with any type of eviction. I tell volunteer attorneys, when in doubt, if a tenant tells them they have gotten a notice of lease termination, always suggest that they request a grievance hearing. They may not be entitled to it if it's criminal activity, but frequently the housing authorities will give them a hearing anyways. So it can't hurt to advise them to go ahead and move forward with a grievance hearing and have that opportunity to go through the administrative process. If it's a Section 8 voucher, this is a little different in that it involves a private landlord. So with a private landlord, there is a private lease agreement between the landlord and tenant, but there is also a HAP contract, a housing assistance payment contract, which is a federal contract between the housing authority and the landlord. The lease agreement controls unless there is a conflict between the HAP contract and the lease agreement. Often, if there is an alleged breach of the lease, the private landlord can simply move forward with the eviction and does not have to give any other advance notice other than the notice to vacate, does not have to go through a grievance hearing. However, when the landlord sends out that notice to vacate, they are required to send the PHA that notice at the same time as the tenant. And many landlords skip this step and do not notify the PHA, and that will be a defense to the eviction. So it's important that if you're talking to a tenant and they tell you they're on a voucher and that they've gotten a notice to vacate, and then the landlord has subsequently filed the eviction lawsuit, they need to get in touch with their caseworker at the PHA to find out, was the PHA notified at the same time and given a copy of it? If they weren't, there's a defense to the eviction. There's procedurally, they haven't followed the correct steps to move forward with the eviction. Also, it's important to note that a landlord cannot evict a tenant for non-payment of the PHA's portion. So on a Section 8 voucher, the tenant has a portion that they're required to pay, and the PHA pays the remainder of the rent. And if the PHA for some reason has not paid their portion, such for an example, perhaps the PHA has abated the rental assistance for the landlord's failure to repair, a landlord cannot evict a tenant if the tenant has paid their portion of the rent. And so they're precluded from filing an eviction for non-payment of rent against a tenant. So that's a very brief overview of subsidized housing, and a quick overview of landlord tenant law in general. So now I'm happy to take some questions. I'll stop sharing my screen. And I see we've got some questions in the Q&A already. So let me look at those. First question. Is a second suit required for a landlord to cover late fees, etc.? Will that be filed in JP court? The answer is yes. If the landlord in the eviction lawsuit can only recover past due rent. So if the landlord wants to file to recover late fees or any other fees such as damages to the property or whatnot, then the landlord would have to file a separate suit. They could do that in justice court or county court, but they would have to do that. Next question is, for the city of Dallas rental assistance, does the tenant still apply through the TEDP? Is there a list of rental assistance programs who still have money? They don't have to apply through the TEDP. For the city of Dallas, they can apply directly with the city. Unfortunately, my list of rental assistance programs is out of date. The two organizations I'm aware of that currently have rental assistance other than the city of Dallas is the HCC, the Housing Crisis Center. The other places to look are churches and faith-based organizations. So looking at churches and temples may still have some rental assistance. Many of the United Way organizations that had rental assistance, that has dried up. Writ of reentry, the question was which court? That is the Justice of the Peace Court for a writ of reentry. Next question, what if a client pays for an exterminator after written notice but does not deduct? The client has receipts and wants reimbursement. Unfortunately, the client's on the hook for that, and there is no requirement for the landlord to get reimbursement. Extermination is not one of the things that they can do repair and deduct for, and they would have had to follow the extensive repair and deduct process in order to get that if it did qualify. Such as giving the landlord advance notice that they were going to make the repairs themselves, making sure that they got 3 separate bids and giving the landlord that notice as well. And then when the landlord failed to respond, actually doing the repair and deduct. So Unfortunately, if the client went ahead and paid for it out of their own pocket, they're on the hook for that, and there's no requirement for the landlord to reimburse them. They needed to go through the regular repair process, and I can understand, especially with exterminating, that they probably didn't want to wait or go through that lengthy process, but unfortunately they're not due reimbursement. And Michael Savage has put a note, fair housing only applies to prospective tenants, not current tenants. I was not aware that they've taken that position in federal court. I'll have to defer to your expertise. One of the next steps for this clinic, if you're talking about the HCC clinic, if most of our clinics, we have firms or individuals that want to sign up. You can contact the HCC or contact Maricela. And Maricela Martin will be happy to connect you with the clinic. Although we have the clinic twice a month on the second and fourth Wednesdays, and we're happy to have volunteers for the clinic. We have gone back to in-person as of this month. So the clinic will take place at 6 p.m. on the second and fourth Wednesdays at the Housing Crisis Center. Next question, does the second notice to an apartment for rodents in the unit need to be sent certified mail, and who does the letter need to be sent to? If it's a second notice and the first letter notice was not sent but through a tracking method, it does not need to be sent by certified mail. It can be sent by regular mail and or hand delivered, and it should be hand delivered to the landlord, to the property owner or the property manager. And does the tenant need to provide proof of prior notice and service requests with the second notice? Also, does the tenant need to provide pictures of the rodents? No, the tenant can simply reference the prior notice and does not need to reply to provide pictures of the rodents. Are there any other questions? I see we've got something in the chat. Oh, Maricela just put the CLE and MCLE credit in the chat and the course number. A copy of my PowerPoint will be sent out to the all the attendees. In addition to that PowerPoint, I have created, it's a 17-page landlord tenant outline